Mr. Brearley, can I begin by checking whether this hearing is going to be entirely face-to-face or whether anyone is joining us remotely?
I don't believe anyone's joining us remotely. I think it's entirely face-to-face now.
Fine. Right.
My lords, my ladies, there are two related appeals by Emtel. One appeal concerns CellPlus and its parent company, Mauritius Telecom. The other appeal concerns the relevant telecommunications authority. I shall be addressing the committee in the appeal against CellPlus and Mauritius Telecom, which I will call MT. And Mr. Moulin SC, to my right, will be addressing the committee in the appeal against the authority. So I'm MT and CellPlus. And we've agreed that I finish round about lunchtime. I mean, no discursia, but if I won't introduce everybody because A, I don't know who's speaking.
No,
and I know the committee.
We have a list in front of us. Thank you.
I don't want to be discourteous. So, with my Lord's permission, I will address the committee on the following three issues. First, I will highlight the relevant parts of the 1988 Telecommunications Act, which obviously is central to this appeal. So I'll go first to the 1988 Act. Second, I will address the committee on the first act of unfair competition. That's March 1996 to September 1996. And third, I will address the committee on the second act of unfair competition. That's the breach of the licence conditions. I should point out that I'm ably assisted by Mr. Adamji, who's going to be giving me the iPad with the relevant electronic bundle references. I won't be going to the hard copies. I'll be going to an iPad. I have never argued a case in an iPad before, but
well, something that Council seem not to understand is that we don't have hard copies.
No, that's right.
We have a key documents bundle, which has the judgments essentially, and your written cases. But all we need from you are the electronic
that's right.
page references.
And that's what I'm going to do.
Thank you.
So, with that introduction, could I go first to the Telecommunication Act 1988, and that is at page 3355. 3355. And we see there the arrangement of the sections, and I'm just going to go through the relevant sections to this appeal. The first is at 3356, and I just asked my Lord to note licensee. Section 2 refers to licensee, but license is not actually defined. So Section 2 simply refers to a license issued under the Act. So license is not defined, it refers to licensee. Going on to 3357, excuse me, we see Section 4. This is the section that establishes the authority, the Telecommunication Authority. So there is established for the purpose of this Act a Telecommunication Authority which shall consist of. So it's a public statutory body. Section 5 on 3358 is quite important because that tells us what the functions of the authority are, and it's sections 5 1A to F. It's to monitor, control, inspect and regulate telecommunication services, that's A. B, to ensure that the telecommunication services are operated in accordance with the Act, so we'll see that it has to be licensed. C, to issue, modify, revoke licenses under the Act. D, sanction any tariff or charge under section 17, so that's quite important, we'll see that. And then E, authorise any person to test. And then F is a catch-all, which clearly we pray and aid, to do all such things as may be requisite under this Act. So as we'll see in a moment when we come to Lord Bingham's judgment, there is a very wide discretion afforded to the authority. Section 6, just in passing, because Lord Bingham does refer to it, there is an advisory council. But we go, I think, best to page 3360. 3360. This is section 10, which is quite important. And essentially, section 10 provides that everyone who provides telecommunication services must be licensed. You've got to have a license to provide a telecommunication service for pretty obvious reasons. Section 11, which the Court of Appeal looks at quite a lot, is an application for a license. So every application for a license shall be made in writing. The authority may request an applicant to furnish information. 3, in determining whether to grant a license, the authority will have regard to the public interest. That's 3A. And then one goes over the page to 3361. Every license shall specify the name of the licensee, the installations, location, services, and then this will crop up quite a lot. So this is section 11, 4E. Any terms, conditions or restrictions which the authority may think fit to impose. Again, quite a wide discretion. Section 12 refers to the modification of a license. That looms quite large for some reason in the Court of Appeal's judgment. But I just merely refer to it because the authority may modify a license, and if it does, it needs to give the person 21 days to make representations. Section 14.
You didn't take us to it, but section 9 perhaps is relevant, which is back on 3359, which is the power of a minister to give directions to the authority.
Yes, there was a debate in the trial below as to whether the minister did give such directions.
Whether he does or not, it's the power to do so that
Absolutely,
might be relevant.
Well, it is, because it shows, and we'll see this, the minister had a public consultation. There is a real element of a government wanting to ensure that people act in accordance with the Act. But we're not aware that any specific directions were made. We never got disclosure of it. But nonetheless, as my Lord says, it is important because the minister may give the authority directions as may be requisite in the public interest. And we shall see there was a public consultation exercise, and the authority did liaise with the minister in imposing the conditions on MT and Cell Plus. Section 14, I just refer to because there's duties of the licensee, and 14D, the authority may ask for such reports or audited accounts or information concerning the operations of the services. Section 17 on 3364 is obviously important. We rely on this. This concerns the tariffs or the charges. So anyway,
13 is also interesting. That there's a right of appeal from the authority to the minister.
Yes. That is That's specifically as to the modification or revocation of a license.
Yeah.
But again, it does show that the minister, the government, is heavily involved in the regulation of the telecommunications sector. Section 17 on page 3364 is important, particularly for the first act of unfair competition. It provides any rates, tariffs, or charges proposed by a licence shall be subject to the approval of the authority. So we shall see the newcomer has to propose its tariffs and charges to the authority. Subsection 2, the authority shall not approve any rates, tariffs or charges unless it considers they are reasonable. So there's got to be a thought process as to whether they're reasonable. The authority may call for such information. And then 4 is important to Emtel's case. No licensee shall claim any rates, tariffs or charges which have not been approved by the authority. So there must be an approval of the relevant tariffs, and that is quite important in the context of the first act of unfair competition where Cellplus charged nothing. We move on to page 3372. I'm just scrolling as slow as I can. And section 40, operating without a licence. Any person who establishes, maintains or operates a telecommunications installation to provide a telecommunications service in breach of section 10 or in breach of the terms, conditions or restrictions of any licence in respect to that installation shall commit an offence. So if you operate without a licence or you are in breach of the licence conditions, you commit an offence. Section 41 has other offences. So any other breach of the Act, perhaps for Section 17, the operator also commits an offence. And then we see at Section 42 the penalties. Any person who is basically unlicensed or breaches the licence conditions commits an offence, it's unlawful, and there's a penalty or indeed an imprisonment term not exceeding 12 months. So that is in a nutshell. I'll go to 5912, please. So that in a nutshell is the powers under the Act. As my Lord will have seen, these statutory provisions were considered by the Judicial Committee some 23 years ago in the present case. And I'd like to have a look at what Lord Bingham said in the 2000 judgment, and that is at page 5912. 5912. So we see here the very same players 23 years ago. Lord Bingham delivered the judgment. And in a nutshell, the issue was whether it was ultra vires for the authority to impose a licence obligation that MT would not cross-subsidise its subsidiary Cellplus or grant Cellplus favourable interconnection rates. So it concerned ultra vires to impose a licence condition that MT would not cross-subsidise its subsidiary Cellplus or to grant Cellplus favourable interconnection rates. The Judicial Committee held that the authority had the power under the 1988 Act to impose such conditions on both MT and Cellplus. And the reason was that it was a legitimate policy consideration to ensure a level playing field between Emtel and Cellplus in the developing mobile telephone market. So with that introduction, I just briefly go to page 5913, and we see here Lord Bingham setting out the various sections of the 1988 Act, which we have just seen. So at paragraph 3, Lord Bingham refers to section 4, which is how the authority was established. His Lordship sets out the functions of the authority in section 5, and we've seen that, A, B, C, D, E, F, to do all such things as may be requisite under the Act. His Lordship says there were far-reaching powers, and if one scrolls down, for example, on paragraph 7 on 5914, His Lordship refers to section 10, which, as we've seen, no person can operate without a license. Paragraph 11 of the Act, His Lordship refers to section 17, which is that all the tariffs must be approved. And at paragraph 12, at page 5916, His Lordship refers to section 40. So all the provisions that were in play today were in play 23 years ago. The Judicial Committee considered that the authority did have the power to impose the conditions both on MT and Cell Plus. The authority had a wide discretion to regulate the telecommunications sector. And there are a few passages I wish to highlight which show that. Page 5917. I ask my Lord to look at paragraph 18, and it's particularly in the middle. So this is where His Lordship is saying Emtel did not at the time have a GSM license, it had an analogue license. But we see in the middle of the paragraph, Emtel was, however, greatly concerned by this proposal, which is the introduction of services by Cell Plus, no doubt fearing that the value of its investment in the market would be reduced and its competitive position undermined. And then to pick up the point about the Minister, the government took these concerns seriously, and a committee was formed under the chairmanship of the Prime Minister to review the situation, and the outcome was communicated to Emtel in a letter from the authority dated 25th of September 1996. Now that paragraph is important to the first act of unfair competition because MT and Cell Plus did not wait until this consultation process was concluded. Cell Plus started unlicensed commercial services in March 1996. And by the time it acquired a license, it had acquired 30% of the market. It was at this time charging nothing. But it didn't wait for this consultation process to finish. We see at paragraph 19 to 21 reference to the press release which concerns the conditions imposed on MT and Cell Plus. The obligation on MT not to cross-subsidise Cell Plus and not to give Cell Plus favourable interconnection rates. The interconnection rates are the rates you charge to get connected to the fixed line. And we'll come on to the press release later.
It's crucial, really, because you can't provide a mobile phone service if people can't use their phones to ring landlines.
That's absolutely correct, my lady. And it's also important that the interconnection fee is a very high cost. And so if Cell Plus gets a favourable rate, there is a competitive disadvantage. And this is what the condition imposed on MT and Cell Plus was designed to ensure, a level playing field. But Emtel did not have sight of the licence, it did not have sight of the correspondence we shall see in a moment. It just had sight of the press release where the authority was telling the public, and Emtel specifically, that these conditions had been imposed on MT and Cell Plus. and one sees if one at 5918, I think this is paragraph 7 of the press release. This is repeated in the correspondence, as the committee would have seen, but here we see the two conditions which are fundamental to this case. The authority has further decided that the following conditions be met. The interconnection agreement between MT and CellPlus should be on the same terms as those offered to Emtel, without, however, any grace period as was previously granted to Emtel Ltd. Now, I note that Emtel is specifically referenced here. And B, the authority would appoint an independent auditor to certify that CellPlus is keeping separate accounts from Mauritius Telecom, MT, and that it is not benefiting from any cross-subsidisation. We shall see the judge found that these conditions were breached in such a way that she regarded them as intentional breaches. On the facts, essentially, MT breached those conditions and bankrolled CellPlus for a considerable period of time. And the judge said the breaches were so bad that she could only regard them as intentional. At page 5923, I should add that the committee only had the press release to go on because no one could provide the committee with the licence, and the correspondence was not provided either. So the committee only had the press release to go on. But the press release does say that these two conditions must be met. So at 5923, at paragraph 36, when CellPlus sought a licence to exploit the new GSM technology in the mobile telephone market, the authority decided it should be subject to the conditions specified in the press release. So the evidence does not show whether the minister directed the authority to impose those conditions under Section 9, nor whether the authority complied pursuant to Section 11, but since the decision to grant the licence subject to those conditions followed the deliberations of a ministerial committee, it is at least possible that a direction was given. And then Lord Bingham sets out what I've just said, which is the purpose of these conditions. The purpose of the conditions is plainly to ensure that Emtel and CellPlus competed on broadly equal terms. In other words, to see that CellPlus, as a wholly owned subsidiary of the monopoly fixed line operator, did not gain an unfair competitive advantage. And it's important that Lord Bingham saw this. There was no challenge to the validity of those conditions until Emtel sought to enforce them. And we'll see actually how that played out. At paragraph 37, having set out the purpose of the conditions, Lord Bingham then turns to the power, the vares, to impose the conditions. And his lordship says, the question nevertheless remains whether the authority had power under the statute to impose the conditions, which it is understood that it did. The authority's functions were laid down in Section 5 in the most general terms, and telecommunication services were very broadly defined. The remit of the Council directed attention to the interests of purchasers and users as well as consumers. Refers to the Minister. And then this is the important bit that the judge actually cites when finding that the authority had the power. It had power to modify license, but nowhere in the Act, the authority enjoyed in deciding what terms or conditions to impose on the grant of a license, the authority enjoyed a wide discretion, provided it had regard to the public interest in any directions of the Minister. It had power to modify licenses. Nowhere in the Act is there any indication that the authority lacked power to license competing operators of mobile telephone services if it judged it to be in the public interest to do so, or if it was directed by the Minister to do so. It had power to license such competitors, it plainly had power to impose what it considered to be appropriate conditions to regulate competition between licensees. It cannot be thought that the authority had power to license such competitors but not to control the terms on which they were to compete. So that is the Judicial Committee, Lord Bingham, referring to Section 5, conferring a very wide power on the authority to regulate competition between Cellplus and Emtel. And then lastly, I just want to refer to paragraph 42, which is at page 5925, which specifically concerns MT. So paragraph 42 on 5925, where Lord Bingham addresses the submission by MT that essentially it was immune from any condition being imposed on it. So first of all, the board deals with an argument by Cellplus that it didn't need to be licensed. So the board cannot accept that there was no need for Cellplus as a wholly owned subsidiary of MT to be licensed at all. And as we will see on the evidence, that was not the view taken by any of the parties involved at the time. And the submission ignores the legal distinctness of parent company and subsidiary, because MT had originally applied for the license, then it created its subsidiary, and the subsidiary provided the services. And this is important, nor can the board accept that MT was outside and immune from the regulatory regime established by the 1988 Act. By Section 43 of that Act, the predecessors of MT were deemed to be validly licensed, and Lord Bingham accepts as a fact that he's understood that no license has ever been granted to MT. So Lord Bingham knows that it is Cellplus that has the license, not MT.
But that's not required under the Act for MT to be licensed.
No. Well, MT needs to be licensed as a fixed line operator.
Yes,
Robert.
that's...
But it doesn't...
Right, but
Oh, sorry.
Mr. Brearley, I'm afraid we have a technical hitch with Lord Sales's laptop. I think we're going to have to adjourn until it gets sorted out because he can't access the
No,
documents.
that's very important.
Sorry about
No,
that.
no, that's very important.
We'll resume as quickly as we can.
Of course, yes.
Yeah, sorry about that. I seem to be functional again, so we can resume.
I was just looking at my lady. So 43.8.
And just to help me, what page is that on?
That is
5925.
that is at 3375. 3375.
5925.
5925.
what are you looking at? Are you still in
Yeah.
Lord Bingham's judgment?
No, sorry, I was just. I don't need to. Sorry. I'll go back to 5925.
Yeah.
I was just. My lady said that MT didn't need a license, and I was just. I was just replying to that it would be authorised under the transitional provisions under 43.8. But Lord Bingham clearly knew that MT did not possess the license to provide mobile services in Mauritius. His Lordship says it.
So was there then no power under the Act to impose the no cross-subsidisation condition directly onto MT as part of its landline operating function?
Whether it was part of its landline, in my submission, the answer is in the next paragraph.
Okay.
In the next, if I just go through it, but I think essentially what the committee ruled was that it could be a condition of CellPlus's license. So MT had applied for the license, CellPlus was then operating it, and the powers under Section 5 were such that as a condition for the grant of the license to CellPlus, a condition could be imposed on MT not to cross-subsidise. So that is why we've always said that it was...
Was that because MT was the parent?
Correct. And we see why Lord Bingham said this. He said, after he says it is understood that no licence has ever been granted to Mauritius Telecom, it would, however, and then we get the however, emasculate the regulatory regime established by the Act if the authority were held to have no power to approve the rates, tariff or charges proposed by MT as a monopoly fixed line operator, and the authority would have had no means of enforcing the requirement that CellPlus make an interconnection agreement with MT on the same terms as that between MT and Emtel, unless it could, in the last resort, enforce that obligation on MT as well as on CellPlus.
But you say that how the board envisaged that would be done would be through a licence condition of CellPlus's licence.
Correct. And that,
rather than potentially modifying the deemed licence that MT has as the landline operator.
correct, because at paragraph, I think it was 36, where Lord Bingham is referring to the powers, Lord Bingham is referring to section 5, and we read that as imposing a condition on CellPlus's licence. And indeed, when we get to the correspondence, I think that's pretty clear. Because on, just as you will have seen, and we'll come to it, on the 5th of September, the authority issues 3 letters. One of the letters is addressed to MT and imposes these conditions expressly on MT. We say it did so pursuant to its powers under Section 5, and it made it a condition of CellPlus's licence that MT would not cross-subsidise. And we will also see that MT, in the consultation period, was expressly representing to everybody, including the government and the authority, that it would not cross-subsidise and it would not favour CellPlus. And all that was in the context of trying to get the mobile phone licence. So we do rely on Lord Bingham's, it's quite punchy in the sense that his lordship is saying that it would emasculate the regulatory regime if no condition could be imposed on MT and enforce at the last resort. And
that's on MT as fixed line operator rather than just as parent of the licensee.
It could well be both. It could.
Well, it could be. That's what Lord Bingham is saying.
Yeah.
Well, it's important whether it is or not because of what we've seen about breaches, the seriousness of breaches of licence conditions. But it's not your case, as I understand what you've just said, that MT was in breach of some licence that it held to operate the landline.
No, we've never said that. What we've always said is that when we see the press release, the conditions, the 7A and 7B conditions, were imposed on both MT and CellPlus, and we've interpreted those to be conditions of CellPlus's license.
So it is then relevant that MT wants CellPlus to get the license because it's CellPlus's parent.
But in paragraph 42, the second sentence says, nor can the board accept that MT was outside and immune from the regulatory regime. So in other words, MT itself was directly subject to the regulatory regime.
Yes.
So then he acknowledges in the next sentence that the predecessors of MT were deemed to be validly licensed.
Yes.
And it's understood that no license has ever been granted to MT. It would, however, emasculate the regulatory regime if the authority were held to have had no power to approve the rates, etc., proposed by MT as a monopoly fixed line operator. So in other words, MT's rates, tariffs and charges, proposed rates, tariffs and charges, were subject to the approval of the authority.
Yes.
So it was direct. So, and therefore, if it proposed not to charge anything to CellPlus, that would be a matter which the authority could regulate directly.
Yes. And that was the whole. That's what Lord Bingham was trying to ensure, that
Yes.
that MT was not outside the conditions which were designed to regulate the competition in the mobile phone market.
Yes, and so so it finishes up that paragraph by saying that we would have emasculated, etc., unless the authority could, in the last resort, enforce the obligation on MT.
Yes.
Yeah, so it isn't only I'm not sure it was clear from your discussion with Lady Rose, but it's not only CellPlus that was subject to regulation.
No, absolutely.
MT was.
No, because if during the period of exclusivity before CellPlus came into existence, MT had decided to predatory price landline charges in order to prevent people or discourage people from buying mobile phones, would the regulator have been able to do anything about that? Maybe you want to keep your powder dry.
I've got enough problems already.
The Act isn't just about mobile telephony.
No,
it's not.
It's about all forms of telephony.
Yes.
So, as the as the sole monopoly operator of landlines, MT was fairly and squarely within the confines of the Act, wasn't it? I mean, I find it very strange to hear that the Act merely asserted that MT's predecessor had a valid license, and MT didn't have a license. Well, why didn't MT have a license?
Well, I think
It's that slightly puzzling sentence of Lord Bingham's, where he says it's understood that no license has ever been granted to Mauritius Telecom. What he may mean is that there's no physical manifestation, but it must be deemed to be licensed.
Well, I think that's under the transitional period
Yeah.
provisions.
Yeah.
This is, after all, it's an act which predates the era of mobile phones.
But I think that the important point not to lose sight of is that both MT and CellPlus in this judicial review, which Emtel brought because it was asking the authority to enforce these conditions, they both said there was no power to impose a condition on MT. And Lord Bingham said it would emasculate the regulatory regime if no power could be imposed on MT not to cross-subsidise its subsidiary. And thereby,
I think it's fair to point out, as indeed you do, that paragraph 36 makes it clear that the mechanism for achieving that was by imposing conditions on the CellPlus licence. That's the whole predicate for the board's judgment. So it's looking at the question, is there a power under the Act to impose, by way of condition in the licence granted to CellPlus, obligations on MT? And you say the answer is yes.
And just to be clear, the respondents don't disagree with that to a certain extent. They accept that there was a power, I believe they accept there was a power to impose a condition on MT. The grant of the license was conditional on MT not cross-subsidising. Where we part company on this appeal is that the respondents say all the conditions have to be in one document.
But the Court of Appeal did say, how can MT be guilty of a breach of the licence conditions when they don't have a licence?
Yes.
They were never licensed, so that's how they knock
That's how they do
out
it. They say
that.
it's preposterous.
You, yes, you take issue with that
Yes, yeah.
because of this.
Because we say that MT wanted its subsidiary to have a mobile phone licence, and the authority said as a condition for me granting your subsidiary a mobile phone licence, you must not cross-subsidise your subsidiary. Yeah. And it's as simple as that, really. And we shall see that the condition was imposed in a letter of the 5th of September. MT, for the best part of 16, 17 years, accepted that a condition had been imposed on it, and it was only when we got to trial that it then said, actually, there's no vires. So, but we'll come on to that.
And presumably, just as I get this clear, as I understand it, you say this is ratio. I mean, the power under the Act to impose, by way of a condition on a licence granted to Cell Plus,
yes,
obligations on MT,
yes,
is part of the ratio of the decision of the board.
Yes.
So for all that the Court of Appeal says it's preposterous and so on.
Well, what the Court of Appeal says is preposterous is it's not in one. It's got to be in one.
Oh, I see. Right. That was on the one document point.
So we say obviously if there's two documents to be read together, that is the licence and the conditions. The respondents say, had those conditions been put into the licence, then we wouldn't be here. But because it wasn't put into one licence, the single document theory, then it's preposterous that MT should be bound.
I see. Thank you.
So with that, could I...
Something you might want to think about, just a moment, an opportune moment to mention it, is whether there are any steps which we ought to be taking, perhaps when we give judgment in this case, to make sure that 24 years hence our successors aren't sitting here dealing with this case again, because we're currently on a preliminary point.
Yes, I mean, I think it was Sir Gerald Barling who did the first case. Sir Nicholas Green did the second case, and I've been around doing it for about 8 or 9 years, and I'm a newcomer. Could I please then, so that is the legislative background, and we do say there's a ratio that the authority did impose conditions on MT. It's a condition of Cell Plus's licence. Could I go to the first act of unfair competition, and I need to go to the facts because of the way that the respondents criticise us, and go to page 1601. And I just note that is the mobile licence granted to Emtel on the 23rd of May 1988. So Emtel was the first operator. It invested in the infrastructure and started acquiring the subscribers. Then please go to 1687. Let's do it on here, please. So 1687, this is MT.
The licence fee that's referred to there, is that a fee to the telecoms department?
Yes, I think there's a fee paid to the authority. Yeah. Then at 1687, in 1993, MT applies for a mobile phone licence, and the authority on the 17th of March 1994 basically says that you can, we will grant it to you. It will start from January 1996, but you've got to submit a plan. So we now know that the second mobile licence is up and running. Then we get into 1995 at page 1619, because Emtel's...
Sorry, at page?
I beg your pardon, 1619.
Thank you.
This is where we start to get the consultation about the level playing field. And this is Emtel, 16th of October 1995. In view of forthcoming competition in the cellular mobile market, we'd appreciate if you could look into the following matters to ensure fair competition. The new digital company to be a separate company. This is Emtel has got a wish list to ensure a level playing field. It's a separate company. There's transparency as to costs. Point number 3, the GSM company must pay the same interconnection charges. There should be conditions about the prevention of a cross-subsidy, etc., etc. So this is Emtel really trying to ensure that the authority is going to regulate this properly.
The Emtel license you showed us at 1601 predates the 1988 Act. Was it granted under some earlier legislation?
It was granted by the DOT. It was the first order by the DOT.
Oh,
88 license.
I'm told by Mr. Mulan it was actually granted by the Department of Telecoms.
Yes.
Department of Telecoms.
Yes.
I think it was then re-granted when the authority was set up. Was it?
Yes.
Yeah.
Yes.
I see. Okay.
Yeah. So it's the department is but I don't think we need to go it up. But it's 1601. 1601. The department granted it, and then it was re-granted as my.
Yes, I see.
So we've seen on the 16th of October, Emtel being very concerned about the level playing field. And then the next document I'd like to go to, please, is 1690. 1690. This is MT. It hasn't set up Cell Plus yet. This is MT, 16th of November 1995, letter to the authority, submitting a memorandum. It wants various things. I just we'll go to 1639. So this is the memorandum that MT is saying it will.
I think you mean 169.
Oh, sorry. Yes, sorry. 1693. Yes, sorry. Where this is the start of MT making a commitment that it will ensure a level playing field. So at 9, commercial autonomy. The operations of the mobile communication system within Mauritius Telecom is vested in an autonomous unit. It will file its own accounts. And then at 10, it will keep separate accounts. This also means there will be an interconnect agreement between MT and Cell Plus. The present provisions of the interconnect agreement applicable to the analog operator, that's Emtel, will be applicable to Cell Plus. So that last sentence, MT is representing to the authority that it will provide the same terms and conditions as regards interconnect as it does to Cell Plus. We then go to page 1624, which is a document that the judge relied on, as we'll see in a moment.
I'm sorry, which was the page?
I beg your pardon, it's 1624. 1624.
Thank you.
Now this is Cell Plus. This is Cell Plus's publicity, and it is seeking subscribers, and it is essentially providing services to these subscribers. It is billing the subscribers for international calls, But most importantly, it is charging a zero tariff for local calls. So it will be noted that all local charges will be on a complementary basis for a period up to end May, except for international calls, which will be billed directly to you. As we shall see, both respondents said at this time MT and CellPlus were only testing the network. This is a question of fact. The judge found as a fact, after hearing the evidence, cross-examination, the documents, that by this time, CellPlus had started commercial operations, unlicensed commercial operations, at an unlicensed zero tariff, free calls. And that was for a period of 6 months. And that is how, by the time it actually got its license, it had acquired 4,000 subscribers and a 30% market share before it was even licensed. So this was a piece of evidence that the judge relied on at trial to reject the response.
Do we assume that everybody who signs up with CellPlus unsigns themselves from Emtel? I mean, there'd be no reason.
That was basically the premise. So some of them were new, but Emtel certainly had a 7% growth and then went down to a 1% growth.
And we just don't know where these first customers came from, do we?
No, we know. I'd imagine some were new because it is a new service, a digital, but one knows that, and I don't think we need to go into the detail, but Emtel's expert, Mr. Forrest, calculates loss and damage as regards this period. So that is the publicity, and so if we go then to 1695, again, this is all part and parcel of the government consultation period, 24th of April 1996. This is a letter to the authority. And it says, on behalf of CellPlus and the parent company, MT, I herewith submit a memorandum for the urgent reconsideration of the following. They want an exclusive period of 7 years for the digital services. They actually end up getting 3, and they need a license. And a copy of this memorandum is being submitted to the Minister of Telecommunications, again, showing this is all part and parcel of the public consultation exercise. If one goes to section D at 1698, section D at 1698, you see there what MT says. MT is fully aware that questions have been raised by interested parties, that's clearly Emtel, includes Emtel, relating to the needs of having separate accounts in order to avoid cross-subsidization of services. In anticipation of the above and with a view to ensure total transparency, MT will be operating its mobile services under a subsidiary company known as CellPlus Mobile Communications Limited. The latter has been incorporated, now a legal entity. MT will ensure that its subsidiary company pays for all services and infrastructure at commercial rates. So again, all in the context of no cross-subsidization. We then go to, if we could, page 1705. 1705 is a letter dated the 17th of June 1996 from CellPlus to the authority. This is quite an important document because CellPlus, as the judge found, at this time is operating commercial services, and it is charging nothing. It is a zero tariff. And as we've seen, Section 17 says that all tariffs need to be approved. And this is CellPlus coming up with its official tariffs. So 17th of June, we hereby submit the official tariff structure for calls and services which will be applicable once approved by your authority. As we shall be going live commercially on the 1st of July 1996, in brackets, the judge found they'd gone live already in March, we shall appreciate if you can forward to us at your earliest convenience the approval of the authority. So again, recognising that the tariffs need to be approved. They then go on to say, we wish to draw to your attention the fact that should the approval be delayed, we shall have no alternative than to continue with the present trend of friendly users. And the reference to friendly users is to the subscribers being charged nothing for local calls. And we submitted, and essentially the judge accepted at trial, that was a brazen disregard of the law. It was operating unlicensed commercial services at unlicensed tariffs to the detriment of CellPlus, to the detriment of Emtel. And if we scroll down, we see here the tariff structure and the charges that they have submitted for approval. And so, for example, on page 1711, you see here the tariff plan, 5 rupees, 3 rupees, 1 rupee 50. Again, this is still during the consultation period. CellPlus has no license. The zero tariff has not been approved, and it's in June that they are seeking approval for the tariff. We're almost there. 1625. This is a further advert. Again, CellPlus haven't had its tariffs approved by the 1625. CellPlus have not had its tariffs approved.
Sorry, what's the date of this?
I think it's 4th of July. So this is July.
Somebody's written that on it.
It has. I don't believe it was.
July 96.
Yes, 4th July 1996. I don't think that's it in dispute. In fact, I think the judge refers to it. But CellPlus wishes to inform its subscribers that the friendly user campaign has been extended until further notice. So it's continuing to charge nothing for local calls. And so CellPlus still has no license. 1702, again, MT is still representing, this is a letter from MT to the authority, 12th of July 1996.
I'm sorry, what was the page number?
I beg your pardon, it's 1702.
Thank you.
1702. Again, this is part of the consultation period, 12th of July 1996. MT is still committing to the authority and to the government that CellPlus will be running at a separate cost centre and it will be paying essentially commercial rates for any sharing of infrastructure, etc. So this was a commitment essentially as a condition for the grant of the license to CellPlus. MT is saying we will not cross-subsidise. And then if we go, and this is the last document, if we go to page 1626, as I have said many times now, and Lord Bingham referred to it at paragraph 18 of his judgment. This is page 1626. This was a paper submitted by Emtel on the 13th of August 1996 to the Ministerial Committee. Again, trying to ensure that there is a level playing field in the mobile
So this was its response to the consultation?
It was. And we obviously haven't got time to go through it, but I will make two passages. Page 1630. I just refer the committee to that page of 1630, because Emtel is still trying to ensure that it gets a level playing field. For example, the last bullet, there must be no cross-subsidy between MT and Cell Plus. And if one goes over the page to 1631, here we have Emtel complaining at this point that Cell Plus is operating without a license. And the penultimate bullet point is giving unlimited free call to customers, almost 6 months. So this was doing, as the judge found, serious damage to Emtel at the time. So those are the documents. Can I now turn to the pleadings? And I have to do this because of the way that the respondents are criticising us in their written case. Because essentially, one of the grounds that the respondents, or at least Cell Plus says, is that we didn't plead the loss and damage in respect of this period of 6 months. And we just say that is completely wrong and fanciful, but I've got to take the committee to it because the point is made. So can I go to Emtel's statement of claim? So when I go to the documents, I'll just try and identify the document first and then go to the page. So page 8, page 8, that is Emtel's third amended statement of claim. At page 11, at paragraph 4, it refers to section 10, need for a license, and section 17, the need for tariffs to be approved. But the important paragraph is paragraph 11.1 on page 14. Where Emtel pleads, Emtel and Cell Plus calls to be imported a substantial number of portable handsets compatible with and required for the use of the mobile cellular services contemplated to be provided by Cell Plus and cause them to be sold to the public at large by means of a wide and aggressive advertisement. The owners of those handsets were provided with and did use commercially, as from the 15th of March, the mobile cellular telephone services set up by MT and Cell Plus and allowed free calls for over 6 months, although Cell Plus was not licensed to do so until the 5th of September 1996. So that's where Emtel is complaining about the unlicensed activities for this period, which everyone calls period 1. And at section 17, paragraph 17, which is on page 18, Emtel avers that the actions of MT, the concerted actions that MT and Cell Plus constitute a fault and are tortious. So it pleads the unlicensed activities for that period, and it pleads a tort. And before I go to the defences, I just need to go to MT's written case for today. If we go to 3192, Cell Plus criticises us, but at least MT does not take this pleading point, because we see in MT's written case, paragraph 37, in June 2000, Emtel lodged before the Supreme Court of Mauritius a statement of claim, and then 38, the torts complained of, MT was set out in 11.1 and 17, which we've just seen, the third amended. Such torts were, from the 15th of March to the 5th of September, MT and Cell Plus set up mobile services for commercial use when CellPlus had no license to offer such services, and during this period, CellPlus customers were given free calls. So CellPlus, for reasons only it knows, says that we haven't pleaded it, but MT does not take the pleading point. We then turn to MT's defence, and that's at 358. So that's the defence. I just highlight it as the document. The relevant page is at 366. So this is the reply to paragraph 11.1.
And this is CellPlus, is it?
No, this is MT. I beg your pardon. This is MT's defence. At 366, and I won't go through it all, but there are in substance two responses here. First, MT, and we'll see CellPlus say, first they say it was only testing during this time. So there was a live issue, factual issue, at the trial as to whether indeed during this 6-month period CellPlus was testing.
So that's what you mean by a friendly user. It's someone who's not going to complain that the service is terrible because they're getting it free and they know that
Yes.
they're the guinea pigs.
Yes.
Well, yeah.
And the judge rejected that. They said that there comes a stage at which the testing is over and commercial services begin. And the judge found on the evidence that it began in March. So the factual issue at trial was whether the services provided were just testing or whether it was commercial. And the other point that the MT makes is that the license was backdated.
Yes.
So basically, it's D and E. CellPlus's defence is the same. The start is 565, but the relevant page is 570. And all I need to say really is that this is page 570, paragraph 18. CellPlus responds to paragraph 11.1 and says there was testing purposes to a small, this is C, testing purposes to a small number of selected persons. We saw MT said it was 300. The judge found as a fact that it was 4,000 by the end of August. And again, they make the point that the license was backdated. And the important point that the respondents have to grapple with is, when I will come to it, is that yes, the license was backdated, but the license never authorised the free calls. It never authorised a zero tariff. So the respondents can refer...
But it's stats, it's the zero tariff that did you the damage, not the...
Absolutely. But we say that we can't... You can't salami slice it and say, well, I was entitled to operate the commercial services, but forget about the zero tariff. If you're operating commercial services at a zero tariff, that is unlicensed. And we'll see. It just were never... The zero tariff was never sought, it was never approved. They never sought approval for it. It was essentially a fait accompli. And that it did untold damage to Emtel. So those are the defences. Can I then, I need to rattle through this, the evidence at the trial and submissions. And again, I have to do this because of the way that CellPlus in particular criticises. And what I'm trying to do here is just impress upon the committee that this loss of market share for this 6 months was a real live issue as a matter of fact, as a matter of expert evidence, and as a matter of legal submission. So if I can go to the our closing submissions, and again, this is at 5249, which is just to identify the document 5249. But I would like to go to page 5262. This is the section in the closing submissions where we deal with this factual issue. Was this testing or was this commercial services? And I haven't got time to go through this all. We're not in the trial. But for example, paragraph 65 at 5263, we submitted that there comes a time when the testing is over. Clearly you might be expanding the network to a certain extent, but you are providing commercial services. And then at paragraph 67, we refer to the evidence, the factual evidence, which showed in our submission, and it was accepted, why CellPlus was operating commercial services. 67 refers to the evidence of Mr. Yinko, who we cross-examined. That was a CellPlus witness called specifically for this period 1. We referred to that document we've just referred to about the friendly users, and at paragraph 74 on 5265, we say this conduct on the part of MT displays a brazen disregard of the law. It didn't have a license, and the backdating of it didn't cure it. We refer at 75 to if it did have the power, what about the two conditions about non-cross subsidy? And then at 76, we say this unlawfulness was further compounded when CellPlus openly published in the national press the fact that the policy of free calls and free value-added services, for which there should be no license, would remain available until further notice. Moreover, even when the authority approved CellPlus, it continued with the unapproved tariff until the 1st of October. So those were the submissions on the issue of fact as to whether this was testing or commercial services. Just for the committee's notes, so if one goes to page 5290, I think that is where we refer to the cause of action. So there was an element of French law involved here, because the cause of action is based on the code, and it's Article 1382 of the Mauritian Civil Code, and it concerns the concept of concurrence déloyale, unfair competition, and paragraph 180, we see there, for unfair competition, a concurrence déloyale, to be successful, it's necessary to be a fault, damage, and a causal link.
So there's no separate competition law, it's all based on this?
There is now, but there wasn't then, it wasn't retroactive. So it was based on the old-fashioned unfair competition under the 1382. And that was debated at length from the judge. And really, there's no argument on this appeal, nor below, that if one operates an unlicensed activity, that is an act of unfair competition. If one breaches those two conditions, assuming they are conditions of the license, that is an act of unfair competition, particularly when we have seen that the authority imposed those two conditions to protect Emtel. At page 5330, Emtel instructed an expert from Price Waterhouse, a Mr. Forrest. So this is at 5330, paragraph 317, we say the evidence for Cell Plus soft market unlicensed activities prior to September 1996 is set out in section 2, which we've seen. And then we refer to the expert evidence of a Mr. Forrest, who calculated the loss for this 6 months. And I should add that the expert evidence was not seriously challenged, if at all.
And that, I haven't studied the detail, but was presumably against a counterfactual of no trading by Cell Plus
it
during
is.
that period,
And
rather than trading under the backdated license.
it was, indeed, my lord. So if one then goes to page 5454, this is the expert of Mr. Forrest at PwC. It was a very detailed document. And if one just flips to the contents, one will see, the background, the basis of the claim. He has to deal at section, so this is page...
Sorry, I missed your page number.
I beg your pardon. So the 5454, 5454.
Yeah.
This is his first report. He did other reports as well, but this is his first report. 22nd of April 2016. One only has to look at the contents page to see how detailed it was. And he is looking at a counterfactual after the license was granted. But if one scrolls down to section 10, this is on page 5457, yeah. That is his calculation for the market share loss for this 6-month period. And how on earth Cell Plus can say this was not pleaded and advanced at the trial, I just simply do not know. And if one goes to page 5540, we see his report. This is the section dealing with the market share, where in this section he does refer, this is all relevant to the counterfactual. The market share loss provides an additional quantification of loss. If Emtel's allegations that Cell Plus commenced commercial operations prior to its license start date, he calculates it, overview. He says at 10.1, Emtel also alleges that Cell Plus had been operating commercially without a license. Whether or not this allegation is true depends upon the factual evidence, and that's the factual evidence we saw in section 2. And I won't, I mean, the details do not matter, or all that matters.
Can you say briefly why he fixes on August rather than September?
I think because the license was granted on the 5th of September, and I think he just took...
I see.
And you see at 10.7 and 10.8, at page 5541, he specifically refers to period 1 and period 2. And frankly, again, I can only say, I do not understand how Cell Plus can say that we didn't advance a case at trial concerning period 1. It was pleaded, MT accepts at this hearing that it was pleaded, factual evidence was adduced, and we had considerable economic evidence, economist evidence, as to period 1. And lastly on this, it is important, because this is Cell Plus's argument.
Did Mr. Forrest analyse an alternative case based upon a counterfactual that assumed that the backdating of the licence was effective, but nonetheless there would therefore be a difference between the tariff they were actually operating?
His first calculation calculated the loss from the 5th of September, So assuming that it was lawful
Yes.
for the prior period, and that's the glide path. He looks at the reasonable tariffs coming down.
Well, that only starts on the 5th of September.
And then he says if it actually Cell Plus should have started on the 5th of September, Emtel would not have lost the market share that it did in that 6-month period.
So the first calculation is on the assumption that their testing argument wins the day,
Right.
and that there's no breach or unlawfulness prior to that.
Yes.
And then this is dealing with, if we're right and there was a commercial service at zero tariff,
It increases the loss.
Yes.
And that was the basis of his expert evidence.
I may have misunderstood, Mr. Greeley. I thought that the expert's approach to period 1 was on the hypothesis that you were right, and this was unlicensed trading.
Yes, that's
And that therefore the counterfactuals, no trading at all by Cell Plus during period 1.
that's right.
But as I understand it, there isn't in the report an alternative fallback case for period 1 of a counterfactual that they were allowed to trade, but only charging the tariffs in the backdated license.
Well, I think the way that he calculated it, and it was argued that we start off with period 2.
Yes.
And we'll calculate the loss and damage on that basis.
Yes.
If Emtel is right and Cell Plus was operating unlicensed commercial services for that 6-month period, which he then called period 1, it would increase the damages.
Yes. Well, I think your answer to my specific question is there isn't an alternative case by way of counterfactual that Cell Plus was entitled to trade during period 1, but only by charging the tariffs specified in the backdated license.
No, it wasn't. No.
Well, because nobody was arguing, it wasn't Cell Plus's case that they had been charging those tariffs over that 6-month period.
Correct. So it was, that's right. Yeah, that's why
they were saying it was free, but it was just testing.
Yeah.
I mean, I quite understand why there wasn't. I'm just asking.
No. You're right. So, lastly, on this, before we get to the first instance judgment, again, I'm trying to meet Cell Plus's case on this. Can I go to Cell Plus's closing submissions? This is just to identify it. This is at page 1486. 1486. Just to we see what it is, but then go to 1537, where Cell Plus address this loss of market share claim, 175, and then, given the time, I just would like to go to page 1538, to see what Cell Plus was arguing. At 181, paragraph 181, Cell Plus say the license of Cell Plus was made effective from the 4th of March, so that it was licensed for the period of claim March 1996 to September 1996. There can be no claim that Cell Plus came too early on the market, because the period is covered by the license, and the claim for market share for loss of that period can only be premised on the fact that Cell Plus was not licensed during that period. And then at 185, since the whole market share loss case is based squarely on the fact that Cell Plus was not licensed from March 1996, the claim is bound to fail because Cell Plus was licensed from incorporation, albeit retrospectively. This is Cell Plus meeting the plea at paragraph 11.1 that there was a tort that they were operating commercial services unlicensed for a period of 6 months. And yet I'm faced with the argument that, the Court of Appeal accepted it for some reason, that we never advanced this case. And we just said,
But did they then say that the zero rating was also approved, or I think they say now that that's swept up in the backdating of the...
They make two, so they don't really address it. They make two, we say, very astonishingly poor points, which is that section 17.4 refers to, you got to, about claiming a tariff, And they say, well, we never claimed any tariff because we didn't charge anything. And we say that's an astonishingly poor point, and we'll have a quick look at that. And then they say, well, when we submitted the official tariff in that June letter, clearly the authority knew about the free calls, to which we say, well, that's not seeking approval for a zero tariff. You sought approval for a 4 rupee, 5 rupee tariff, just to say we're going to continue with free local calls is not seeking approval, and there was never any approval by the authority. The license that was granted, we shall see, the license that was granted it contained the 4 rupee tariff. So even if the license was backdated, it never approved the zero tariff.
But it would be difficult for them to maintain a case that it was approving a zero tariff when their case was that they hadn't charged a zero tariff because it was just testing. Yeah, so.
Yes, you can't really ride both horses at once.
Well, they've ridden many horses. They've swapped horses quite a lot. But I take the point, and I agree with the greatest respect. So can I just quickly show how the judge dealt with it? Because, again, the Court of Appeal, in my submission, is quite unjustified in the criticisms of her judgment. Just to identify it, it's at page 2698. 2698. And then at 2713, so it's at 2714. Actually, sorry, I beg your pardon. No, sorry, 2713. Just at the bottom, you see with regard to events which took place in the year.
Yeah.
And then if one goes over the page, the judge is referring to the allegation that Cell Plus started commercial operations before its license date and without a license. By so doing, Emtel alleges that it incurred a loss in the market share. So the judge is referring to the market share case there. Then, if we go to 2715, this is where the judge refers to Emtel's contention that Cell Plus started commercial operations before it obtained its license. And the judge clearly recognises the submission that I was making, that the evidence clearly shows that Cell Plus began operating a public mobile service within the meaning of Section 10. She refers to Mr. Yinko's evidence, who was the Cell Plus witness to deal with this. She deals at 69 with the letter that we've seen, the friendly user and the local charges. At 70, the judge says that I rightly submitted that by letter to the friendly user, Cell Plus was seeking subscribers, and the subscribers were using the network and were being billed for international calls, but the domestic tariff was set at 0. So she makes a plain finding of fact that essentially that Cell Plus was setting a domestic tariff of 0. She refers to the letter at 71. We've seen the 17th of June when Cell Plus seeks the approval of its official tariffs. And then she says at 72, to my mind, the clearest proof that Cell Plus started its commercial operations before it obtains its license. By the end of August, it had already acquired 4,000 subscribers. In its defence, it said 300. Cell Plus said a small selection, 4,000, and that was broadly 30% of the market. So that was her determination on the factual issue. She then deals with Mr. Forrest's loss of calculation. and I'm going to have to go quickly over this because looks like running out of time, but at 2742, down below paragraph 191, the judge refers to Mr. Forrest's calculation of Emtel's loss. She goes on, we see at 2743 the glide path. At 2747, the judge specifically...
Just on the glide path 2743, we see the figure and the claim period. Is that the second period?
I think it is, yes, it is. Yeah.
So that would be starting September?
September, yes. And as competition intensifies, the costs go down. So this is dealing with the period 2. Then if one goes to 2747, I mean, the Court of Appeal says the judge didn't address her mind to the market share loss case. Well, yes, she did at 211 and 212. In fact, I don't believe the Court of Appeal referred to these paragraphs of her judgment, but she refers to the loss of market share at 211, 212, and Mr. Forrest's calculations that we've seen. That's referring to his section 10. She also, again, the Court of Appeal don't refer to these paragraphs at 213 to 215, where she refers to Mr. Forrest gives more detailed analysis of the assumptions underlying his calculations of Emtel's loss under cross-examination. So she actually refers to the cross-examination by my learned friend Mr. Chetty, who's in the court today, and at 215 and 216 she refers to the period 1, which again is the market share loss. At 2752, she refers to the cause of action. And again, I have to, then at 2777, oh, I've lost it. At 2777, the judge refers to Mr. Forrest's calculation of loss, which includes loss for period 1. And then lastly, if one goes to page 2782, the judge awards, thank you, Emtel doesn't get all the loss that it sought. The judge actually cut the glide path to a shorter period, so it wasn't all in Emtel's favour. But she said that Mr. Forrest had been conservative. We see that at 350. And she can rely on his calculations. And at 351, the calculations of Emtel's loss by Mr. Forrest in the market share loss scenario are set out, and that's the document we saw in his expert report. In the light of the evidence establishing that CellPlus started its commercial activities before it actually obtained its licence on the 5th of September, albeit the licence was backdated to March, I find an award for damages is just. So she addressed her mind to the question of testing, she addressed her mind to the question of backdating, and it's my submission, it's plain as a pikestaff that the backdating never approved the operation of commercial services at a zero tariff, and she was entitled to come to the judgment she did. The appeal, and I'll take this quickly, the appeal, if one goes to page 2850, we see that it's the paragraph at the bottom. The Court of Appeal refers to criminal liability, but we've referred to unlicensed operations, which actually it is penal, but it's still unlicensed. But it's the passage on 2851 at the top, 2851, essentially the last sentence on the issue of backdating. In any event, it has not been shown how CellPlus or MT can be found tortiously liable for carrying out commercial services during that period in the teeth of a valid lawful amendment that CellPlus's licence, when on the face of it endorsed the legitimate exercise of commercial services from March to September. And we say it is just plain that is wrong. It is simply wrong. The backdating did not legitimise the operation of commercial services at an unauthorised tariff, which caused such untold damage.
And you say you can't split out the two.
It's very difficult to see how you can.
Yeah.
And also, I don't think the respondents advanced the case based on splitting out, saying, well, even if we were wrong to apply a null tariff, we could have applied a tariff of 4 rupees, in which case...
I will wait to see what they say, but I don't believe they do, my lord. No, they don't. And just before we go on to the second act of our unfair competition, just to put some detail on this, if one looks at the licence itself, so it is said that the backdating of this licence cures everything. If one goes to page 1642, this is the licence itself. So this is Clause 7 is an express term of the licence that they say was backdated. The licensee will charge the subscribers appropriate fees as described in the 3rd schedule hereto. All changes in call charges should receive the prior approval of the Telecommunication Authority. So if we go then to 1654, we see what the 3rd schedule says. And those are the tariffs that were approved. Nowhere do you see the ability to charge 0 tariff for a local fixed to mobile call. And just lastly, so that it can't be said that I haven't addressed the point on the backdating, if one goes to page 3233 of CellPlus's written case, 3233, in order to escape this, they say, so far as Emtel seeks before the board to rely separately on the fact that during period 1, CellPlus did not charge for domestic calls, this is where I say they make the 2 astonishingly poor points. In allowing calls to be made free of charge, CellPlus did not claim any rates, so they say, well, we didn't claim anything, we didn't charge anything. Well, if that is, I'll see how that is articulated.
So is that a translation from the French? I mean, is the French give us?
Well, it is actually. It is section 17.4 does refer to claim. It does.
In both
it may. But I mean, it would mean that even when a tariff had been approved as reasonable, say 4 rupees, so you've submitted your official tariff, it's approved, CellPlus could go ahead and reduce the tariff to 0 and say, I'm not claiming anything, because I'm not charging anything. We say that's not a sensible interpretation of section 17.4. They rely on section 17.4. But in any event...
But you say it's a licence condition anyway. So.
A licence condition anyway. Yeah. And section 17.1 says that the tariffs must be approved, and it's in the licence clause 7 that they must be approved, and they were never approved.
So just to understand what they're saying, the quote, any rates, tariffs or charges, that seems to be a direct quote from section 17.1.
So if one goes to page 3364.
Oh yes, no, it's all 17.4.
If we quickly go to page 3364.
Yes, I see. Yes, in fact, it's all a quote from 17.4.
Yeah. And we say well, it's not a sensible interpretation of section 17.4, but in any event, they didn't comply with section 17.1 because they never sought approval for this. And in any event, clause 7 of the licence, if that was backdated, didn't give them the right to charge a zero tariff. I will leave, because given the time I've touched on it so far, I will leave the lack of pleading point and the fault point, and I need now to go to the second act of unfair competition, which is how the licence conditions were actually imposed. So we need to go to 3 letters, and when I refer to these letters, I would ask the board to have in mind CellPlus's argument that our case has evolved, which is, we say with the greatest respect, nonsensical, because we've always relied on the press release, we've never relied on the letters. We shall see that we rely on the letters. And the judge refers to the letters. But so when I refer to the letters, it is with a view to rejecting CellPlus's argument that our case has evolved, which it hasn't. But the way that the conditions were imposed it starts on the 5th of September. So one goes to page 1715. So there are 3 letters of the 5th of September. So this is a letter to CellPlus. Please find enclosed the original copy of the license issued to your company to operate the GSM, the digital mobile telephone service. And the letter encloses the license which follows, and that includes clause 7. Then if we go to page 1731.
Yes, we're going to get that clause 7, that's the one about approving the tariffs.
The tariffs.
It's different from 7A and B in the press release.
It is, yes.
Yes.
Yes, it is, yes. Yes, we're going to come on to the 7A/B of the press release.
Yes, I'm just making sure I got it in my mind.
Now this...
We're on 1731, did you say?
1731. So, as I understand it, CellPlus and MT says, well, a condition has to be in this single document. So this is about this single document theory. But this is a letter, and you don't find, this contains a term to the benefit of CellPlus. This is not found in the single document called the license. And in this letter, the authority grants CellPlus 3 years exclusivity. So with reference to the initial application made by MT, for exclusive rights to operate the digital mobile phone service, I wish to inform you that the Telecommunication Authority has approved the grant of 3 years exclusive rights to your company for the use of GSM technology. So again, this is relevant to the respondent's single document theory. They're quite content to have a term of their license in a separate document when it benefits them, but they object to the condition, which we're just about to see, being imposed on them in a separate letter. So this is the letter the 5th of September granting 3 years exclusivity, granting rights to CellPlus, and it is a term of the license. So that's the second letter. The third letter is at 1732. So this is the correspondence which imposed the condition on MT. So this is reflective of the press release. So the press release indicated to Emtel and the public that the conditions had been posed and had to be met. But this is specifically drawing the two conditions to MT and to Cell Plus, who is copied. These are the two conditions which are reflected in the press release. So I wish to inform you that the authorities approved the grant of a license to Cell Plus to operate the mobile service, and that MT should offer interconnection to that company on the same terms and conditions as those offered to Emtel without any grace period. So that means with immediate effect, because what happens is that MT object to this. They want to favour Cell Plus for a period of time. The authority will shortly appoint an auditor to determine whether Cell Plus Mobile is keeping its accounts separate from MT and that it is not benefiting from any cross-subsidisation from MT. So these were the conditions in the press release. They were essentially the commitments made by MT and Cell Plus during the consultation period, which were commitments given essentially to get the grant of the licence. And this is the authority informing MT and Cell Plus that these are two conditions of Cell Plus's licence. And then the press release, which we have not seen, but it is at page 1638, and we have seen it because it's in Lord Bingham's judgment, but just for the reference, it's at page 1638, thank you, and at 1640, we see the two conditions in the press release which are specifically addressed to MT and Cell Plus in that 5th of September letter. The authority has further decided that the following conditions be met, and then we get the interconnection agreement, no favourable treatment to Cell Plus as regard interconnection charges, and B, no cross-subsidy. As Lord Bingham stated at paragraph 36 of the judgment, for the note, that's 5923, there was no challenge to these conditions until Emtel sought to enforce them. And if one goes to page 1735, this is a letter from MT dated 22nd of October 1996. I haven't got time to go through it all. But essentially what MT is doing here is pushing back on the two conditions. Having got the licence, it now doesn't want the conditions to be imposed. And we see here that MT is objecting to, it refers to the 5th of September letter, and at point 2 wants an amendment to the terms of the letter and essentially MT wants to have a period of time when it can give Cell Plus favourable interconnection rates. It doesn't like the grace period, and it wants the whole of the second paragraph to be deleted. So that's the purpose of point 2, and it's.
Do you say that we can rely on these post-license documents to what? To say that these were conditions, or they're prevented from arguing that they're not conditions, or what is legally the... Well, I understand why you're taking us to them, but where legally do these come in? They can't make them conditions.
No, I do take that point, that if they don't have the power, if the
it's not whether they don't have the power, have they exercised the power?
Well, if the authority does not have... there was a Vires point before. Do you have the power to impose the conditions? And the board said yes. Then 20 years on, we're met with another Vires argument, which wasn't raised before, but is raised now, which is, although you got the power, you didn't put them in the single
You didn't
document.
exercise the power.
You didn't
by
exercise the
including
power
those,
properly. And they
imposing
say,
those.
well, the committee never addressed its mind to that, but the point was never argued. And so it is, to a certain extent, background. I do pray and aid Lord Bingham, who did say, I think it's at paragraph 40 or 41, I think it's 42 actually, that about the Cell Plus license, the parties didn't believe that was correct at the time. So Lord Bingham thought it was kind of important background. But I can take it swiftly because it is ultimately it is a question of vires at the end of the day.
But I mean, in terms of exercise, doesn't it show how the addressee of the licence actually understood it?
That's right, absolutely, my lord, and not only understood it, but then accepted it in the defence. So we had and accepted it. Essentially, going before the Judicial Committee and it goes to an abuse of process point, which we do raise, that you accept it, you commit to it, you then try to wriggle out of it, you accept that there were conditions, but you want them changed. You don't say that there's a vires issue like this when you go to the Judicial Committee 23 years ago. You accept it in your defence, and we will see that very quickly. And then when you get to trial, all of a sudden, contrary to the pleaded case, Emtel is faced with this single document interpretation. So it's not as if MT and Cell Plus didn't believe that they were conditions at the time. They certainly did. And that's why they challenged the vires. So I'll take this quickly. All I need probably to do is we've got these three letters which set out the conditions. If one goes to page 1749, MT partly gets its way because what happens is it's in 1749. On the 4th of February, the authority replies back to this 22nd of October, and at B says the authorities maintained its earlier decision that essentially the rates should be on the same terms, the interconnection rate should be on the same terms. It confirms in C that there should not be any cross-subsidisation, but at the parties, the respondents' request essentially, unbeknown to Emtel, I should say, the authority says we will not appoint an auditor, an independent auditor. You can provide reports and information to tell us there's no cross-subsidisation. And I won't go on, but at 1751 there is a further letter. MT continues to resist, and at 1753 the authority says you shall abide by B and C in this letter, and that's where the matters were rested. 1751, 1753, that's where it rested.
Copied Cell Plus, or it's actually written to MT?
Yes.
And the licence was not a public document?
No, so when Emtel on the 25th of September 96 was given a copy of the press release, the authority said these are the conditions that have been imposed on MT and Cell Plus. Emtel asked for a copy of the licence and it was refused. And so Emtel never had a copy of the licence or of this correspondence we've looked at until shortly before the trial. And that's why I understand, I think it was Sir Nicholas Green who argued the case before the committee last time, Emtel asked for a copy of the licence and the committee asked for a copy, but it could not be provided. So the copy of the licence and this correspondence was not provided for some 15 years. And that is why Emtel had to plead the press release in its statement of claim. And that's why it's so unfair to say, well, Emtel has been under an evolving case when all it had to go on was the press release. Quickly going to the pleadings, I have to do this because of the way that CellPlus argues it. So can we go to Emtel's statement of claim? I'll just give the references. Emtel pleads the conditions at paragraph 8 to 10. This is at page 12. At page 17, at paragraph 15, it avers that the conditions were imposed on MT and CellPlus. And at page 18, paragraph 17, avers that the acts were tortious. So at page 12, it refers to the conditions. Page 14, it avers at paragraph 12 that there was cross-subsidisation. At page 17, at paragraph 15, avers that, again, the conditions were imposed. And at page 18, paragraph 17, avers that the acts were tortious. Again, I won't go back to it, but at page 3192, MT, in its written case, accepts that Emtel pleaded a tortious claim based on breach of the licence conditions. It is important to see how the respondents dealt with this in the defence, because, as I've just said, it's consistent with the way that they looked at it in the correspondence, and after the Judicial Committee had said that there was vires to impose the conditions. So MT's defence is at 358. It's paragraph 16 at 364. Where they aver, so MT, defendant number 2, avers that the purpose of the conditions imposed was to encourage fair and healthy competition amongst all operators and to ensure that defendant number 3, that's CellPlus, should not benefit from any cross-subsidisation. So they basically accept that the conditions were imposed on them. At page 368, again, in the context of this apparent revolving case of ours, at paragraph 21.1, this is at page 368, the MT refers to the letter of the 4th of February that we've just seen. So it does refer, it doesn't refer to the 5th of September correspondence, but it does refer to the 4th of February, which is the letter which said that the interconnection condition was maintained, the cross-subsidy condition was maintained, but no auditor need to be appointed. So they refer to the correspondence there, which is correspondence where the authority is again imposing the conditions on MT. At paragraph 25 at 372, essentially denies that the conditions have been breached. So it accepts the conditions were imposed, and at paragraph 25, it states that the conditions have been complied with. And for the committee's note, I won't go to it. CellPlus's defence is in almost exactly the same terms. It's at page 568 at paragraph 15, and CellPlus pleads by reference to the press release and denies any subsidy or favourable treatment has been given to it. So this is at page 568 at paragraph 15. So for the best part of 16 years, that's how it rested. The respondents were accepting that the conditions that had been imposed, but they had not been breached. There was no cross-subsidy and the rates were not favourable. So if I go back to our written closing at 5249, just to identify it, but then go to 5279, this is again our closing. We set out in some detail the authority's powers and how the conditions were imposed on the respondents.
Sorry, which paragraph?
I beg your pardon. So, well, it starts at section 5, so it's paragraph 136. So this is a chunky section where Emtel, in its closing, explained how the conditions were imposed on the grant of Cellplus's license. And really, I'm just trying to address the point that we refer to the letters. So at 5287, this is at paragraph 168. We say they can properly be described as license conditions. So in any event, they were freestanding conditions of the grant of the license. And we got various bullet points. But we, for example, and all I'm doing here is meeting Cellplus's case that we've never referred to the letters. It's an evolving case. We've always referred to the press release. We see the second bullet, there is no reason why the conditions cannot be imposed in an accompanying letter, such as the letter of the 5th of September 1996 and subsequently the 4th of February. So I really don't understand why Cellplus continues to maintain this. And at 5288, again, we refer to the 5th of September letter and the 4th of February letter. Moving on to the judgment of Judge Chung, the first instance judgment, if we go to page 2718, again, all I'm doing is emphasising the fact that Cellplus make this submission. Again, I don't understand how the judge has not addressed her mind to the 5th of September letters. And the Court of Appeal will basically say this. But again, we see at paragraph 84, the judge referring to the 5th of September letter, enclosing the licence and then imposing the conditions. And then at paragraph 89, she refers to the other letter which grants Cellplus the term of 3 years, the exclusivity. So it's just simply wrong to say that...
So that document D327 was that second letter?
D328 would be the...
I'm looking at 89.
Oh, sorry, 89 would be the...
1731 was the second.
1731, thank you. So the exclusivity is 1733, and then 1731 is the imposition of the terms, yes.
I think 1731 granted the 3-year exclusive right.
Right. So 1731 granted the exclusive right. So that, yeah. But I'm obliged. And so it's just simply wrong to say that the judge didn't address her mind to this correspondence. I don't actually understand it. If one then goes to para 90, the judge refers to the press communique, so it's, which she does because it explains the rationale for why these conditions were imposed. And then at page 2755, at paras 244 to 254. This is the section of her judgment where she says, does the para 7A and 7B of the press communique set out conditions of Cell Plus license? She says that it does. At 246, so we're at page 2755, whether paragraph 7AB as amended sets out conditions, and that's amended by the correspondence, sets out conditions of the GSM license must be considered looking closely at the press communique and the language in which it is couched, also in the light of the circumstances surrounding it. The evidence on circumstances leading to the issue of the communique and of the inclusion of 7A and 7B on the events and its issue and the intention of the parties leaves no room for doubt that 7A and B set out conditions. And she sets out various reasons why they were conditions of the licence, in large part because the parties understood that to be the conditions of the licence, but to meet the point that the respondents make, which is, well, it doesn't matter what the parties intended, it all concerns the vires. At page 2756, at paragraph 250, the judge refers to the fact that the conditions reflected the commitment by MT. The judge refers to Section 5 of the 1988 Act, which we saw right at the beginning of this morning, and quotes from paragraph 37 of the Lord Bingham's judgment. And paragraph 37 is the paragraph we've referred to, which said, Lord Bingham said, it's a wide discretion to impose conditions. And clearly the judge is saying here, the authority had wide discretion to impose the conditions to regulate this market. It has a wide discretion to impose the conditions in the correspondence as reflected in the press release. I've mentioned it a few times, we'll go to page 2761, just so that you have this in mind. There's two more paragraphs of the judgment. At 2761, this is where there was detailed evidence, economic and factual, as to whether there was cross-subsidy, whether there was favourable interconnection charges. And she reviews the evidence, including the cross-examination. In my view, the recourse by MT to finance the operational expenses of Cell Plus while the intercompany debt or payables exemplifies the type of conduct that Condition 7B expressly prohibits. As put to Mr. Murrigan by Mr. Brealey, Cell Plus, a subsidiary of MT, was paying for finance at uncommercial rates, which constitutes a clear breach of the condition against cross-subsidisation. The effect was that MT was bankrolling Cell Plus in its operations when the conditions at paragraph 7 were designed expressly to put a stop to this. The breaches were so obvious that they can only be described as intentional breaches. And that there's no appeal today against that finding. And on the evidence, it was clear. Lastly, the condition on MT, because MT say now that they're not liable. This is at page 2762, 2762. It goes on to, this is the kind of new case advanced by MT. Now, it's submitted on behalf of MT that the fault alleged by Emtel can only be committed by Cell Plus. The MT cannot be liable for fault of Cell Plus unless the requirements of 1384, which is the responsibility, basically it's vicarious liability, is satisfied. To my mind, Emtel's claim is correctly based on 1382, which is the concept of unfair competition. Not only in paragraph 17 of the statement of claim, Emtel pleads that MT and Cell Plus acted in concert, that it suffered damage from the concerted actions of MT and Cell Plus, but also on the evidence adduced, which has been dealt with above, the condition against cross-subsidisation is addressed and directed against both MT and CellPlus, and both MT and CellPlus have equal and shared responsibility to comply with the condition. The reason I stated above, I find that MT and CellPlus breached the condition against cross-subsidisation, which they implicitly agreed to comply with, and which was stated by TA as conditions to be met when CellPlus was granted the digital licence. Both MT and CellPlus have intentionally made use of unfair means, leading to a rupture d'égalité dans le moyen de concurrence, and have committed an acte fautif.
The fact that MT was made subject of that condition would be a reason why it couldn't be included in CellPlus's licence.
Absolutely, absolutely, my lady. And indeed, the judge referred to that fact. It made sense for the MT condition to be in the correspondence. The respondents say, well, that doesn't matter because the condition has to be in the single document, which we say is not a sensible interpretation. But that is why the authority put it in a separate document, and the judge said that was sensible. If I go to the appeal, I will we'll see how CellPlus in particular articulates our alleged evolving case, but I hope I've shown that our case has not evolved. We pleaded the press release because we didn't have anything else to go by. And when we did get the correspondence and the licence, we referred to it. So I just finish with the interpretation of the Act. I don't think we do have to go back to it, but it is the Act is at 3355. Section 2, there's no restrictive term of what is meant by licence, so Section 5 is in very broad terms on functions. I just remind Section 5F, the authority has the power to do all such things as may be requisite under this Act. So the Court of Appeal essentially says that it was preposterous for MTB to be bound and that there was no breach of the licence conditions because it wasn't in the single document. So the Court of Appeal relies on Section 11.4e. If I could just go to Section 11.4e so we see it. So it doesn't necessarily rely on Section 5, which says the authority has the power to do everything it needs to under the Act. The Court of Appeal relies, for this single document theory, every licence shall specify any terms, conditions or restrictions which the authority may think fit to impose. So we deal with this in our written submissions, but there are 5, if I've got time, there are 5 logical reasons why, in my respectful submission, this single document theory is wrong, and you can have the conditions in 2 or more separate documents that can be read together. So, first, the single document interpretation, we say, is a strained interpretation of the word licence in Section 2 and Section 11.4. There is no support for the single document theory based on any literal interpretation. There is no express prohibition on the authority from granting a licence to an operator, the terms and conditions of which are contained in 2 separate documents which can be read together. And we say, firstly, the word licence in Section 2 and 11 does not bear the weight of the Court of Appeal's single document interpretation. That's the first point, just on a literal interpretation. There's no support for it. Secondly, we say that the narrow interpretation unnecessarily elevates form over substance. The respondents accept that the 2 conditions would be licence conditions if they were inserted as clauses in the single licence document. But they do not offer any real policy reasons why a term or condition cannot be contained in a separate document which is to be read together, provided obviously that the condition is drawn to the person's attention. In this case, the conditions reflected express commitments made by MT and CellPlus as a condition for the grant of the licence. MT knew exactly that the condition was being imposed on him. Third, the narrow interpretation ignores the wide discretion identified by Lord Bingham in paragraph 37, that in deciding what terms or conditions to impose on the grant of a licence, the authority enjoyed a wide discretion. In my respectful submission, if the authority enjoys such a wide discretion as to the nature of the terms to be imposed, it is not apparent why the authority does not enjoy a similar wide discretion as to how to specify them. If it has a wide discretion to impose the term on MT, we say it has a wide discretion to impose the term in a letter addressed to MT. Fourth, we say that the narrow interpretation ignores the reasoning of Lord Bingham that the regulatory regime would be emasculated if MT, as the paymaster, was immune from cross-subsidising. And it's essentially the same point that we've just made, my lady, which is that in my submission, Lord Bingham recognised that MT was not the holder of a mobile licence. He recognised that in para 42. Nonetheless, in that paragraph, he proceeds to say, however, it would emasculate the regulatory regime. And so the fourth point is that this narrow interpretation, we say, ignores the reasoning of Lord Bingham in paragraph 42. And the fifth and last point is that section 11.4e, which is the paragraph the Court of Appeal so heavily relies on, refers to any term or condition. And this is a point that I've already made, but as we've all seen, the authority afforded a term of 3 years exclusivity to CellPlus in a separate document. No objections taken by the respondents about that term being absent in the single document. They don't say, I can't have the term, and we say that is illogical. And finally, so in my respectful submission, the authority was well within its power to confer such a privilege, 3 years exclusivity, and an obligation, no cross-subsidisation, by 2 documents, 3 documents, the 2 letters dated 5th of September, and this gives the authority flexibility and is well within the wide discretion identified by the Judicial Committee 23 years ago.
What do you say? The point that the Court of Appeal makes is it's got to be really clear what conditions are, because if you breach them, your licence can be revoked and you're committing a criminal offence. And if they're in all sorts of separate documents, how is anyone to know what the licence conditions are?
Well, that's, yeah, I mean, I understand that, but that doesn't mean that doesn't support a single document theory for the reasons I've just articulated, which is that if in that separate document the obligation is clearly directed, addressed to the person concerned, and that person concerned has absolutely no basis to say, I didn't know about it, then why would you say it has to be in one single document?
And you also say that there was enough opportunity to MT and CellPlus to object to the condition,
Well, it goes
to meet, again, the procedural safeguards that the Court of Appeal was very concerned about.
Absolutely. In my respectful submission, those procedural safeguards, essentially is misplaced, because what the Court of Appeal said, I'm not interested in any of the factual evidence. All I'm interested in is the interpretation of section 11.4e. When one actually addresses one mind to, did MT know about this condition? Did CellPlus know about this condition? We say that's why it was important to have a look at the correspondence, because as the judge held, first, MT and CellPlus committed to these two conditions. They represented that these conditions would be satisfied if they were granted the licence, and that is in the period of public consultation. And then the licence conditions were imposed, and MT and CellPlus, for the next 6 months, had ample opportunity to object to them, and did object to them, and actually got the auditor requirement removed. So it had a period of 6 to 7 months before September where it actually committed to this condition. So to say it wasn't aware of it is ludicrous. And then it accepted that the conditions had been imposed, but then, as Lord Bingham said, objected to them. So I understand that point, but it doesn't mean to say that it is a one. It supports this kind of nuclear one document theory.
Yes, thank you.
Can I ask, is your case for damages dependent on there being a breach of a licence?
Well, that's the way we we argued it. We argued so on this second act of unfair competition. We said these conditions, Emtel specifically lobbied for these conditions to be imposed. They were imposed to protect Emtel. And as the judge said, the MT and CellPlus intentionally breached them. There was cross-subsidisation. And the reason that I think it does depend on the breach of the licence condition is because Emtel had to lower its tariffs to meet the cross-subsidised rates. And that's why the claim for damages is between what would have been the proper rate and the cross-subsidised.
Yes, I had wondered if even if there had been no such condition in the licence, you might nevertheless have argued that the behaviour was constituted unfair competition, but that's not how you...
Well, what we did was... I mean, I have to confess something. We do say it was unfair competition, and then when asked for particulars, we would say, well, the licence conditions were imposed to ensure a level playing field.
I understand. And you don't take an abusive process point in relation to this argument being raised at the stage it's been raised?
We do raise it in our written case. I haven't, but we don't kind of labour the point, but we haven't. We've been asked whether we abandoned it, and we certainly don't. We do say that this was raised very late on in the day.
This is the Henderson argument.
It is, and CellPlus refer to the Henderson. If this, because what we really object to is for 20. So the Vires point was argued. Before the board in the year 2000, and can I just have I got 2 minutes, or shall I break now? I don't.
Perhaps you might return to it at 2 o'clock.
Yes, of course. Yeah.
And you perhaps better work out how you're going to manage for time.
I'll be very, very brief. Yes.